Thousands of homeowners on private estates are facing unregulated and uncapped maintenance fees, amid allegations that developers have created a cash cow from charging for communal areas not maintained by the council. Management contracts for unadopted, private estates are frequently sold off to speculators and property management companies in the same way as freeholds and ground rents, leaving homeowners with spiraling fees and nowhere to turn. If a new-build estate is unadopted, it means communal areas such as roads, grass verges, pavements and playgrounds are retained by the developer. The developer then usually subcontracts day-to-day management. These companies then pass on the costs to homeowners, both freeholders and leaseholders, via a deed of transfer which obliges the homeowner, under the Law of Property Act 1925, to pay for maintenance of this land. This is often referred to as an estate charge, or service charge. These are on top of council tax, even though the council doesn't maintain their street. Critics say the system is open to abuse because management companies have no obligation to keep costs down or provide evidence the services they charge for are being carried out. Buyers may find the bills spiral as soon as a management contract is sold on. Lynn Myers bought her tubed leasehold house in Penrith, Cumbria, from developers Persimmon in September 2016. The sales agent told her the estate would be managed by Carlton Meadows Management Company with an estate charge of £100 a year per household for grass cutting. When Gateway Property Management took over in July 2017, it tripled the fee to £308 a year. That's £17,000 from the 55 residents. Myers alleges that the fee includes more than £3,000 postage. "I am on a lower-end income and plowed my late husband's insurance money into this property," says Myers. "I worry that I will be unable to afford this on top of council tax, etc., and also I will be unable to sell. I have been misled by Persimmon and the government." Persimmon says the initial costs had been miscalculated and that it was working with Gateway to resolve the issue. Meanwhile, 40 miles away across a lake district, residents in Church Meadows and Great Broughton are in a similar situation. Richard Ellsworth moved into his Persimmon-built freehold property in May 2013. The estate's 58 residents each pay Gateway a service charge of £125.53 a year, amounting to £7,281 to maintain about 600 square meters of grass. But Gateway's charges don't stop there. When Ellsworth's neighbors sold their home, they were charged £360 for a management pack for the buyer, plus £144 for a deed of covenant. The only part of the pack that is relevant to the sale is a financial statement so that the service charge information is available to the prospective buyer. As the properties are freehold, Gateway has no responsibility whatsoever for the conveyancing process, other than to receive a deed of covenant from the conveyancing solicitors, says Ellsworth. Gateway claims it provided an often exhaustive amount of information to purchasers' solicitors when a sale takes place. It said it was common practice for managing agents to charge fees for sales packs and additional legal documentation. It says the information we are asked to provide varies from development to development, and this is reflected in the amount we charge, ranging from £150 £300 plus VAT. It is best practice for the information to be prepared by professionally qualified staff because purchasers are reliant on information being accurate to enable the sale to proceed as smoothly as possible. Typically, a sales pack contains in excess of 25 pages and is tailored to the development. Private estates were debated in Parliament earlier this month. Kelly Tolhurst, Conservative MP for Rochester and Stroud in Kent, told MPs how homeowners in who bought from Taylor Wimpey and Bellway but are now in dispute with their property management company, SDL Bigwood. Tolhurst went on to criticize Hyde Housing Association and London and Quadrant. The latter tried to charge residents at Lodge Hill, Chittenden, for street lamps and street cleaning undertaken by Medway Council. The Homeowners' Rights Network Hornets is the campaign group fighting for a fair deal for homeowners on private estates. Its main issue is a lack of a cap on charges and that homeowners don't have a choice of provider. And, if homeowners have a dispute, there's no resolution service in place. Kathy Priestley, spokesperson for Hornets and a freeholder on a private estate, says the private estate model seems to be the norm for new-build estates. "We can only speculate as to why this has happened. The main benefactors are the PLC developers who get to keep the estate land, don't have to prepare it to adoption standards and don't have to pay for its maintenance or the commuted sums for adoption," she says. "All councils have to do, under planning, is to ensure there is a long-term sustainable arrangement to maintain the land under the Town and Country Planning Act. They seem to readily accept assurances from the developers that the management company will deliver this. They don't appear to have thought about how this affects homeowners. While leasehold owners have some, albeit limited, statutory protection, freeholders have very few options. They can take cases to court, but this can be expensive and time-consuming. If they decide to simply not pay, they can ultimately lose their home. Any arrears will normally be recoverable as a debt claim in the county court. However, homeowners should be cautious, as the rent charge owner may have a number of options, including the ability to take possession of the property, says Adrian McClinton, associate solicitor at Coffin Mew.